Donald, same question to you.
Thank you. Ohioans have rejected the notion to change the fact of electing judges in Ohio. It was posed to the electorate as a constitutional amendment, and it was resoundingly defeated. The public has control over the elected members of the judiciary in the state of Ohio, and the public adheres and seeks that public accountability in the course of our elections. Given that, the responsibility to provide regulations for the conduct of judicial campaigns in Ohio rests with the Ohio Supreme Court. We're aware of the continuing perception that there may be an influence of campaign contributions in judicial campaigns. I can tell you there is no cause and effect relationship existing, as Judge O'Neill would have you think, between a campaign contribution and a case result. There's no evidence of that anywhere. The fact is that judges are not permitted to accept contributions in Ohio because we regulate that by having them develop a campaign committee for the purpose of raising funds. And those committees are charged with collecting the money, reporting the money for full transparency. This is the way it's been done in Ohio. It's the way it's been done by all 730 judges and candidates throughout our state for a decade. We regulate the minimum and the maximum amounts of contribution that can be made, and those numbers vary for trial courts, intermediate appellate courts, and state supreme courts. Furthermore, we review this matter at the Supreme Court on a regular basis. And it's interesting and I think instructive for all to know that the Code of Judicial Conduct permits judges to accept contributions to campaigns in accordance with those limited regulations and conduct their dockets. And the comment to Rule 2.11 regulating those conducts says this: a judge's knowledge that a lawyer, a law firm, or a litigant in a proceeding that contributed to the judge's campaign within the limits set forth in the rules or publicly supported the judge does not, in and of itself, disqualify that judge. Now that's the regulation that we have in Ohio. It's been there for a very long time. And when our court adopted it, we put it out for public comment. There was no comment from Mr. O'Neill at that time about it. He didn't participate in the committee, didn't have any comment. It's only when he gets a personal gain by making a public statement just before an election that we hear this. The other thing is, I would ask Mr. O'Neill to regulate the fact and admit to the public that the allegations that he raised earlier in describing his background, which challenged Justice Cupp and my receipt of a contribution from First Energy, was the subject of a grievance that he filed. And he hasn't had the integrity to tell you that grievance was determined by a panel of 3 judges to be no conduct violating the Code of Judicial Conduct, and that no good cause is found for investigation of grievances to exist. And he hasn't had the integrity to tell you his complaint was dismissed, and these charges are false.
Thank you for that. We have.
I must respond.
Judge O'Neill, take a moment to respond since your name was mentioned in Justice O'Donnell's remarks. Just a moment, please. Then we have to move on. Yes,
it's the old integrity question. The reality is that disciplinary proceedings in Ohio are confidential. The only person that is permitted to disclose the outcome of a disciplinary complaint is the person against whom it was made. Without hearing. The Supreme Court's disciplinary arm said there is no appearance of impropriety if you take a $6,300 contribution from a litigant 2 weeks after oral argument. No appearance of impropriety without a hearing. It is the problem, the other problem that Justice O'Donnell raises. These committees are frauds. Let's be grown-ups about this. A judge puts together a committee, the committee holds a cocktail party, and the judge goes to the party to thank the people who were there. That's fraudulent conduct. It is the emperor has no clothes.
Cool, that's 1 minute, and Justice O'Donnell's name was mentioned. I don't know if you want to respond to that, or we can move on to the next question otherwise. The next question is for you anyway.
Mr. O'Neill is not my opponent. Perhaps Justice Cupp should have an opportunity to discuss that.
We're so used to being
I will tell you, however, that Mr. O'Neill had no problem blast faxing the media in Ohio when he filed the complaint, even though he now admits publicly that he knew it was a violation. The sad part is he has not the integrity to tell you until it's brought to him that it had been dismissed more than 2 weeks ago.
We are going to move